Hi, I'm going to be talking about antitrust and startup acquisitions by dominant incumbents. Okay, so we're talking about big established firms acquiring small innovative firms. Okay, so in terms of what distinguishes these acquisitions from a traditional merger case, well, here we have one dominant firm and one little guy. Normally, in a merger case, we have two reasonably large firms who are already established. More importantly, the theory of harm is usually a little different here. Ordinarily, in a merger case, the question we're asking is, what's going to be the effect of this merger on competition right away? But that's not usually what we're thinking about in any case involving a startup acquisition. Rather, the concerns relate to future competition. Okay, we're concerned with how is this acquisition affecting sort of the future trajectory of the market. Okay, alternatively, it could be more general than that. The theory of harm could be that perhaps we've got this dominant defendant who's relying on sort of serial acquisitions as a way of maintaining its market dominance over time. And then finally, there are a number of very substantial administrative difficulties that one inevitably faces if you are going to attempt to try and go after some of these acquisitions. And so I'll start there. Okay, so just a preliminary difficulty is that the tools we already have are not all that well suited to deal with the problem of startup acquisitions. And the reason is that, it comes back to the fact that merger policy is usually asking a pretty different question. Okay, it's a much more tractable question to ask what's going to be the immediate effect of this merger. I mean, it's still hard, but it is less hard than trying to predict what's going to happen down the line. And so, because of that reason, we feel sort of comfortable requiring a little more precision in the context of a typical merger case. More precision than I think we can afford to realistically expect in a case involving a startup acquisition. Okay, and so this sort of uncertainty is really the central problem that is really inevitable for any policy regime that you might come up with to potentially challenge some of these acquisitions. Now, this is exacerbated often by some of the difficult things that come up in tech generally, because many startup acquisitions happen in high-tech markets. And that is that, in high-tech markets, or in tech generally, it's hard to define what the markets are. The boundaries between competitors and complementary goods are often fuzzy. And so it may often be the case that we see two firms and it's just hard to say, are they competitors or are they in more of a complementary relationship? It may be that the most accurate answer is just that it's a little bit of both. And so the upshot is just that it's going to be very hard to come up with a set of standards that are satisfying to everybody, because in order to have a sort of practicable enforcement regime, we're going to have to be less precise than we usually try to be. Another concern has to do with innovation. Okay, so antitrust certainly cares about promoting innovation and entrepreneurship. Well, the issue here is that these startups are making a lot of money on these acquisitions, and these are innovative firms. If we are to block a particular acquisition, well, we're depriving the startup of that payout that it would have gotten, and so there's a potential concern that we may adversely affect innovation incentives. If a startup is thinking, well, if a prospective startup is thinking, well, if I develop this fancy technology, I might not be able to have the acquisition I want, potentially that could harm innovation incentives. I will add that concerns about innovation incentives cut both ways. Kevin Bryan and I have a recent paper in which we articulate a number of reasons why startup acquisitions may actually harm incentives for innovation. So I think the right way to approach this problem sort of at a broad level is to just sort of concede from the outset that we're going to make mistakes no matter what policy we maintain. And that includes a policy of just not doing anything. If we don't do anything, then we are going to fail to prevent some dominant firms from relying on these acquisitions to maintain their dominant positions or to expand their dominant positions. Now, if we do have some amount of active enforcement in this area, eventually we'll make some mistakes. I think probably that's true in all areas of law, but this is no exception. So I think no matter what we do, we're going to make some errors, and so the goal should really be to just achieve a trade-off between how precise our standards are and how administrable our standards are. We better make sure that whatever set of questions we ask plaintiffs to answer, that those questions are actually answerable in practice under realistic circumstances. So some useful things to think about as you're mulling over policy options. So one preliminary question is just what sort of antitrust claim do you want to bring? It's not the case that you have to, that the only way to go after these acquisitions is through a normal merger challenge. Moreover, we also have the option of challenging an acquisition either before it happens or after. The traditional way is to go to challenge a merger before it happens, but there are some reasons why it may actually be advantageous to enforce ex post in this context. Another question is what remedies we want to use. Okay, so if we decide that we want to do something, well, then the question is what thing do we want to do? And there are a number of ways, I think, to help improve the trade-off between how precise we are and sort of the risk of making errors by perhaps narrowing the remedies that we use. And I'll talk more about that in a minute. And then finally, there's the question of what sources of evidence we want to rely on. We don't have, in most cases, the ability to answer the questions that we really care most about, which is, again, what's going to be the future effect of this acquisition. But we have to use something, and so there are a number of things that are being considered. One is the value of the transaction as potential signals, and so an important question to ask is how much weight you want to give to these various options that are on the table. So it looks like I went the wrong way. So as I said, one option is to bring a merger challenge. That is sort of the most obvious approach. But again, it does not have to be the traditional approach in which you challenge the acquisition before it happens. That may be advantageous in some situations, but it doesn't have to be. The reason that post-merger intervention is usually unpopular is because it's pretty messy to unscramble the egg, to unmerge the firms. On the other hand, everything about this startup acquisition area is messy already. And it may be that that we have more information ex post, and that would mitigate our primary concern here, which is, again, this significant uncertainty about the actual economic effects of the acquisition. Another thing to think about is whether a merger claim is even the right kind of claim in most situations. I think in many cases, a more natural fit would be something like a monopolization claim. Okay, and so here, the theory of harm would be not necessarily that a particular acquisition is anti-competitive, but that perhaps a pattern of acquisitions is playing an anti-competitive role sort of as a whole. And the theory there would be that the defendant is relying on this pattern of acquisitions as a way of maintaining its dominance. And that is, very much in line with what monopolization claims are all about. Another benefit of this approach would be that you may have more information. Just to the extent that you are challenging a bundle of acquisitions and not just one, you may have more information to work with. This may cut against some of the uncertainty concerns. So remedies, again, this is the question of what we want to do when we decide that we want to intervene. And I think this is an under-theorized area of the debate over antitrust and startup acquisitions, because it's a good tool, a good policy lever for potentially reducing some concerns about stepping in and doing something when you don't have highly concrete evidence for a likely anti-competitive effect. And so a good example would be compulsory licensing as an alternative to just blocking the merger. Okay, so this isn't always a viable option. It's a viable option when the startup, its technology or whatever it is that it sells, it's something that can be licensed. Okay, so this is often the case in tech, where the primary assets may amount to a bunch of IP, intellectual property. And IP can be licensed. So one possibility is then you tell this defendant, we're not going to block your merger, but we are going to require you to offer licenses to at least a few important firms in your market. And you have to, of course, set it at a reasonable price. So the benefit here is that, well, it's a less severe remedy. The stakes are lower. We need not be quite as concerned about making errors because the fallout from an error will be less pronounced. Now, the most commonly discussed defense in merger enforcement is efficiencies. An acquirer may indeed have a plausible argument that there is some efficiency that comes out of its acquisition. Okay, so I think a plausible such argument would be that there is some complementary relationship between the startup technology and whatever the incumbent, the acquirer, sells. Okay, and so as I mentioned earlier, this is something that happens a lot in tech, where it's hard to clearly delineate firms as competitors versus sort of more complementary firms in a complementary relationship, and so it is plausible that we could have two companies that are competitors in some respects and complementary in other respects, and that complementary component is a plausible efficiency. And certainly we should not disregard these kinds of efficiency arguments, but I think it's important to note that we should also not just assume that they're true. Because plaintiffs are not going to have concrete evidence to rely on, it would be quite, it would be probably fatal to an enforcement effort if we were to just presume that any amount of complementarity between the acquirer and the startup's technologies is sort of presumptively efficient. And this issue of efficiencies is another area where remedies are relevant. So an efficiency defense, to be a valid defense, the asserted efficiency needs to be merger specific, which just means that the only way to get the efficiency is to have the merger. Okay? Otherwise, we could block the merger and still get the efficiency. But again, the remedy does not have to block the merger. That's not the only option on the table. So this is another area where compulsory licensing can be helpful. It is not hard at all for a defendant to articulate a sort of vague argument about complementarity between its own technology and a startup's technology. It may be true, it may not be, and it's hard to tell which is which. Now, the benefit here of compulsory licensing is that, well, we're not trying to block the acquisition. So the defendant can't, it's no longer a valid argument to say, well, you shouldn't intervene because we're in a complementary relationship and it will be fruitful for us to join forces. We're still letting them join forces. We're saying instead, you can't have exclusive access to this technology. You have to sell a license to at least a few other firms. And it's harder to come up with an efficiency defense in that case, because now it has to give an argument saying, here's why I need to have exclusive access to this technology. And so, you know, for this reason, we would be able to maintain a higher bar in terms of what we're demanding from defendants in order to make a viable efficiency defense. And that is all I have for you. Thanks for your time.